First of all, if you are a client comes to you and is a member of a family of a victim, perhaps grandchild of a victim of the Nazi era, whose art has been stolen or taken in some way, but not just confiscated, but done through various transactions, and it's traveled through Switzerland, it's traveled perhaps to Holland, perhaps not. It's perhaps traveled and then ended up in the United States, where it sits in a museum after a gallery had it, sold it to a rich person, and then that person decided to take a whopping tax deduction because this art now is so valuable. And the Jew who originally owned the art was relieved of it for pennies on the dollar. What are the questions that come to mind? What are the questions as a practitioner that come to mind is when this client walks in and says, you know, I want to get my art back? And I wonder if you might be able to just kind of flag some of the issues and questions that would immediately occur to you that you would want to know from your client.
Want me to start?
Yeah, why don't you do that, Larry?
Well, that happens a lot. And when they come in, you try to get the history. As Ray talked about, history is a clear aspect of this, and provenance research, as Sharon talked about. You try to find out all the facts, find out what documentation there is about what the family had when they had it, what title, how they prove title. Sometimes that can be done through title documents. Sometimes it's a photograph of a Picasso hanging over a couch in their grandparents' house. That's work too. And you get all the facts. You then have to find out who the family is, who the family originally was, who the heirs are. We've had cases where there were as many as 30, 40, 50 heirs. You've got to make sure that you find all the heirs because if there's a claim, all those heirs may have a claim, and you may find yourself faced with a motion to dismiss for failure to join parties, or you may find that in the middle of the case, new claimants come in. You have to find out then what happened to the art, and there are different ways it could have been taken. As you say, it could have been confiscated, could have been stolen by the Nazis, but in terms of how our courts view these cases, forced sales by the Nazis, as happened in the Hautsticker case, are treated the same way as theft. And if there was a forced sale, you have to find out all of the elements of that. You have to find out then what transactions occurred after that, to the extent you can.
Let me just jump in on forced sale and the question of duress, because a forced sale where a person has been, a confiscatory tax has been leveled on this person because they have listed all of their assets pursuant to Nazi law, and then there is a special tax that's imposed on them that nobody else has to pay, that basically will deprive them of their wealth completely, and then they sell the art in that context. That's one scenario. Another scenario is you're on the run and you're trying to flee to get to Switzerland and maybe to get to another country, and you just simply have to bribe people. You have to pay flight taxes at airports, and various people are trying to extract money from you on the way, and therefore you need to raise money to do that, and you sell at more arm's length under those circumstances. Are those questions relevant, and how often do those come up?
Judge, you know, in that question, one historical thing we have to remember is that even after someone left the Reich, the Nazis would go after their families. And so even if they were in Switzerland, there might be a death threat against the families unless they liquidated property and returned it. So just glancing at it and say, well, they were in Switzerland, they were in safety, is very naive. And that's an assumption we see in a lot of the fact patterns.
And this is particularly true in Italy, correct, where the Nazis and Mussolini were working in tandem in the late 30s.
Yeah, and there's a history, for example, Sigmund Freud. He had left, And his family was stuck up, and he sent money back so that his family wouldn't be murdered. So if you look at those transactions, you say, oh, gee, Sigmund voluntarily sold his stuff. Unless you have the correspondence that we see in the files. This was a systematic extortion of families, really beyond imagination.
The another question that I have here is, if you're in this kind of a scenario where you're dealing with art that has traveled via various transactions through various owners in different countries, to what extent does the choice of law question break out and become a choice of law for various aspects of the overall case? In other words, different choices of law depending upon what the issue is. Where was the duress? Where was the sale? That kind of thing.
The courts are not in agreement on that. I mean, we have argued in cases that wherever the theft was, the law of that country should govern the theft. When it gets sold, let's say in New York, the law of New York should govern that. But the courts are not necessarily agreeing with that. And after the Bacalar case, the courts are deferring to the courts are saying that if it was in New York for 30 or 40 years, doesn't matter where it was stolen and what happened before, New York has the greater interest in it under the new conflicts analyses. We don't necessarily agree that that should be the case, but the courts are leaning in that direction. I recommend people, and it's on the web, to read the complaint in Lefman against Metropolitan Museum of Art, where you'll see what we believe was an extraordinary recitation of duress of a German family that had to leave Nazi Germany and ended up in fascist Italy and then fled to Switzerland. It's almost your scenario. We think it constituted duress. New York law was applied by the district court, who said they didn't think that it was duress because duress in New York has to be direct from the other party of the transaction. That's a dispute, and it's up on appeal in the Second Circuit.
Now, Monica has suggested that, and talked about the relevance of ADR and working through these cases to try and see if they could be settled. Is that an approach that you take at the outset, or do you try and do you feel that as a lawyer you must bring the case first and before you approach a museum?
Well, I'm a litigator, and people come to me really as a last resort. They've tried everything. And, the economic realities of these cases means that I'm not really looking for another one. I am deeply grateful to my firm for supporting me for the 13 years I've been litigating this estate. So it's not like I don't think, Larry, didn't say it. Larry's much more active in this and much more of a hero, I think, in this area than I've been able to be involved with. But it's really, it takes a tremendous investment.
Well, can I say one thing?
Yes, please.
I agree, but we always still try to resolve these matters. And, for example, in the Houtsticker case about the Chronics, we had 2 failed mediations. It took 3 or 4 years to do those mediations. So I have to say that we try, but I think generally the disparities of the plaintiff and the defendant in these cases are so extreme that it's very, very difficult to settle them. I know Monica has been very successful in resolving claims, both when she was at the Holocaust Processing Claims Office and at Christie's, and many claims we've settled too. But when the claims become larger, when they become, when you're dealing with large collections of very valuable pictures, it's very hard to bring the parties together in a settlement, and that's why you're having these long-term court cases.
Do you think it would make sense there has been talk here of the possibility of getting Congress to focus on this, and this day and age, it's hard to imagine them focusing on anything except beating up on each other. But apart from that, either get a committee of illustrious people who are steeped in this problem and senior museum officials, senior representatives of other communities to come together and form a kind of a commission and reach a kind of a consensus that you might be able to, if you could reach a consensus, do more than just what the Washington Declaration did, which just took you so far, and then talked about a fair and just solution and dropped it. And see if there could be some kind of mechanism set up that you could take these cases out of the judicial system with all of its uncertainty.
That's been tried. And there are many people in this room who I see who have been at those endless meetings at the State Department over the last 10 or 15 years where we tried to get a commission. And the difficulty is the European commissions are generally based on national museums. It's the federal governments who, in the 5 countries who have set up the commissions, and that's why they work. Here you have a system of mainly private museums, and it's my perception, people may disagree with me, that it's been very difficult for the museums to agree to take it out of the courts, because as someone said earlier, they like being judge and jury, and if not, relying on technical defenses in the courts. That's just the way it is. My view is that there should be an alternate solution, but it should be more like the HERE Act, that finally, after 10 years of trying, first in New York State and then on a national level, and again, many people in this room worked on it over those years, Congress finally took it up and passed a legislation that solved the problem, or at least many of the problems, not all the problems. And I think that maybe Congress should take up the substantive issues as well, not just the limitations issue.
Okay.
And Judge, the Federal Bar Association, I'm active with them, and they've taken up the issue and support a commission on this topic. And that's one of the things that was in the Washington Conference Principles. There was some talk that within the DOJ, there's the Foreign Claims Tribunal, and that was an existing structure that might be used for this purpose.
Well, there was a time back at the time of the release of the hostages in Iran when a claims tribunal was set up at that time, and there were funds put into it, and people could come and make their claims. You'd have to find a source of funds, and people would have to donate to it, and then there would be a presumption of it's the equivalent of a very loosely conceived class settlement in which the class is varied and the facts are all varied. It would never fit under Rule 23. But somehow people could, if somehow there could be a common fund set up that could help at least get some recompense, where it's so difficult to prove particular cases. Some cases are easier to prove, but many aren't. And what I'm hearing from you is that the law is very uncertain in this area. That it depends on the jurisdiction you're in. It depends even on the judge you have, and there's so many variables that you can't predict. It's very hard to predict what the outcome is going to be. I'd like to ask Bill Pearlstein a question, and that is, you've talked about how the courts have stepped in now, and basically with McLean, and then in the Fifth Circuit, and then in Schultz here in New York, and informed and enforced the National Stolen Property Act criminally to in effect support foreign jurisdictions, general ownership, statements of patrimony law, patrimony in which they claim ownership to property that they've never seen and that is not in their possession, and thereby, in effect, really dried up the trade, it seems to me, in much of antiquities situation.
Yeah, dried up the trade. I mean, it's interesting. What's really dried up the trade is the 1970 rule, and whereby the American Association of Museum Directors, or Association of American Museum Directors, took the position that they wouldn't access by loan or purchase or gift anything without clear provenance to 1970. Now, clear provenance is a subjective term. I mean, I've been in I had a litigation involving a Renoir consigned to Christie's. There were 6 different provenances. So provenance is itself an interesting concept. There's no title registry. And what's happened as a result of the 70 rule is that you have had hundreds of thousands of objects that, I don't want to say they're consigned to oblivion. There might be a private dealer market for them. The museums won't take them. The auction houses are increasingly cautious, as they should be, because Larry's going to jump down their throat if a stargazer, comes up for auction, just as, a plaintiff's lawyer jumped down Bellagio's throat, in my case, where Renoir came up for auction. And when you represent a consignor and a claim hits the auction house, your consignor is helpless. Their object is tied up, their money is tied up. The consignment agreement, unless you come to me first and ask me to negotiate it, is going to tie you up and protect nobody but the auction house. Excuse me, Monica. Sorry, it's sort of true. And you got to indemnify the auction house. So the antiquities market is tough. The best dealers are very careful. They survive. They have some of the best material at the TAFAF Armory shows. The people who are in business intend to stay in business, and they're very, very careful. Sometimes, if they're really smart, they get someone like me to look at them. The fairs are very careful about the material, but it can't insulate particular objects sometimes from claims which have various degrees of merit behind them.
Right. But part of the problem, I gather, is the fact that you have national patrimony laws that are just declared. Anything that's in the ground that was as of a certain date is owned by the state, and that is, they could have gone a different route, and they could have just said, it's a violation of our export laws, our local export laws, to take these out of the country. They didn't. They claimed ownership.
Right.
And the ownership is now the ownership right of that country is being recognized in this country, and so theft can lie from a deprivation of ownership.
Exactly.
And so I'm interested in what you might say about the fact that these patrimony laws really are what is drying up the market. I mean, is that really the problem, or are there other issues?
Well, I think it's the existence of patrimony laws creates the potential liability that has driven the museums to take refuge in the 1970 rule,
Right.
which has had this sort of derivative or spin-off effect or follow-on effect on the private market and the auction houses.
So that raises a question about antiquities in the sense that sort of if you step back and try and imagine, well, what is the best outcome that one could have if you are a sort of internationalist and you think that the value of this art should be experienced by the maximum number of people, not just the owner, not just somebody who's the Peruvian government or the Congolese government, but worldwide. Is there a solution to that can be worked out either through unilateral legal or policy development on this country, or would it have to be perhaps through a convention and some sort of broader?
Well, my one brilliant idea is actually 2 pages and about 8 paragraphs in that vast white paper, which somebody actually paid for, which is in the materials. And I think, the big problem is there's no title registry, so you got a clear title. So I propose a 21st century solution where you publish, you expose, you vet, you give people, countries, archaeologists, claimants, 5 years. I'd like 4 years because that's the UCC warranty of title. You give them 4 years to make a claim. You have some sort of rational claims process. And after the 4 years come and go, it's free and clear. But that's a market-oriented solution. It's met with virtual silence. Nobody's interested except me, not even my partner. And it'll go nowhere, and you'll continue to have the situation where Larry sues and, people like me defend.
So let me ask my 2 friends on this side, do you have any comments based upon anything that has been said at this point that you'd like to, that anything occurred to you that you would like to comment on?
Well, interestingly, Interestingly, I sort of want to add to something Bill said. It's not even just the patrimony law recently that we tend to think of in a particular country, like 1939 for Italy, or something like that, but several countries are going back to even earlier laws, so that the subject is getting a little grayer in terms of when is legal to have acquired a work. I know this because we gather all these laws, as I said, and they're very hard to even obtain, almost impossible, which just makes it very frustrating for someone who really does want to follow the law. So I've noticed that pattern, for better or worse. I've noticed that pattern. Obviously, when you're dealing with antiquities, there's a separate issue, which is separate from law, which is that no one wants looting. Looting is an issue. And so there's a balance between the law, and I think they get merged because the sides get to be the collectors, museums on one side, and the countries and the archaeologists on the other side, effectively. But in fact, the countries and the archaeologists are slightly different, because one of the issues is you don't want destruction of archaeological sites, and you want them documented. This is important, I think. So there's that issue, and then there's the separate issue of what is the ownership and patrimony law of the country. They're connected, but that's the issue. Is there a good antiquities collector? There are many people who think that's an oxymoron. I don't happen to be one of them. I think that you can be a good antiquities collector and be ethical and follow the law. But some extremists might say that I'm wrong in even feeling that that's possible. So.
Good. I would like to see if
Can I make
yes,
one?
please, Larry.
Since my name has been used so much, and it looks like I frivolously run into court every other day, let me say that my view is that there has been a diminishment in the market, but it's a diminishment in the illicit market. That's all it is. I complained a few minutes ago about the inconsistency in Holocaust restitution. I'm delighted there's consistency in something, and it's that even before McLean, in cases before McLean, and all the way up through Schultz and after, there's been consistency that ownership laws of foreign countries are being honored, but it's not so simple. I've been litigating these cases for 48 years, and the fact of the matter is that just because there's a law doesn't mean you win. Under the McLean case, it has to be clear, and you have to make sure that it's clearly declares ownership of these antiquities in the state. Then you have to come and identify them. You've got to prove they were at a particular site. You have to know when it came out, and you have to know that there was a law in place that was clear at the time they came out. These are very difficult cases to litigate, but the bottom line was resolved by the Schultz case, where we worked closely with the U.S. government, and the issue was, is the CPIA dominant over the NSPA? And the answer was no. One deals with the export of property, one deals with the ownership of property. And it was settled then, and maybe it will change later, but for the moment it's settled. But it's still a hard job to prove that your ownership law works and that you have a right to recover that particular piece of property. And when something was taken under the ground, out from under the ground, it's not so easy to prove it was there. And in our first case, the Lydian Horde case, which those of you who follow the field know about, they were taken out of tombs in the dark of night, and we had to bring archaeologists in from the U.S. and from Turkey, and they meticulously showed that there was a compatibility between the objects taken out of Turkey and those that remained. So it's a pretty hard thing. It's not frivolous, and it's something you have to prove.